Hello, everyone. Thank you very much for joining today's webinar. It's another week, another day. It's a beautiful day today in Southampton, and probably it's mostly sunny in the UK. And if you are joining outside from the UK, um, I think you are enjoying the pre-summer, I would say. Uh, Today, I'm Dr. Shah Siddiqui discussing employability and neurodiversity at a Neurodivergent Business Consortium live webinar. Every week, we bring a special guest and we talk about neurodiversity to ever you what is out there and how you know to conduct or live better. So if you are watching this webinar uh, at home or at workplace, please be aware the safety is the first, and save yourself, the safety, safeguard yourself, and a lot of other things. As an individuals, neurodivergent person, we are neglected sometimes. So safety is first, safeguard is first, and we will introduce our guest speaker today, and he is the fabulous Richard Hiron. He is the employability lawyer, and I will ask Richard to introduce himself to the audience, and we will start our conversation. We will have a good conversation today to understanding the aspects of laws and how we can understand our rights better. So, Richard, thank you very much for joining this webinar. So, if you could introduce yourself to the audience, please.
Thank you, and thank you for introducing me and for having me with you, Dr. Shah. I'm Richard Hiron. I'm also known more popularly perhaps as the Hironator. And what I do is I'm an employment law solicitor, but I also have a background, if you like, in human resources. So that helps me to work with businesses and with HR professionals to ensure that they're doing the things that keep them out of the employment tribunal, not the things that are designed to potentially put them in there in the first place.
Muted myself. Thank you, Richard. As you know, neurodivergent people, we normally don't understand our rights very well, and we suffer, and we don't want to go ask someone if we need clarifications. So we're going to be talking more on the employability and law and how we can protect ourselves and how can we protect our interest and so on. So, Richard, you're working for many years, and you have helped many neurodivergent people and non-neurodivergent people as well. So when you work with employability and law, what specific areas do you focus on?
Oh, that's a good question. I think it can stem into lots of different areas. I think the ones that particularly crop up most of the time are employability or recruitment in the first place, and also managing the ongoing relationship. At its worst, it can move into kind of dismissing people, which is never a fun thing to do for anyone, unless they have something really wrong with them. So it is very much about recruiting in the first place and managing throughout the process. And I mean that there are other topics within that we can kind of move into.
Yeah, that's great, Richard. And I just wanted to discuss openly today. When we are in workplace and we need to understand our employability and laws, what is out there. So, is there any specific places that neurodivergent people can go, or get help when they are, they don't understand a specific topic or specific laws or specific rights?
Of course. Of course. So I'd say that the main focus really is to look at, first and foremost, the ACAS website. Mm-hmm. So that gives an indication on health generally in the workplace. And the reason why I mention health is that neurodiversity itself, it's an emerging thing, even though it's been kind of, how can I say, grouped together in terms of lots of conditions, if you like ADHD, dyslexia, bipolar. They've all colloquially just been grouped in together and called neurodiversity.
Mhm.
Whereas I think we're starting to see more of an appreciation that neurodiversity in the modern age is just thinking differently about things.
Mhm.
But we still have that old model, if you like, of how to manage things. And that stems a lot from what we call the Equality Act 2010. Now, I don't want to offend anyone when I say this, because it is obviously, it's a 14-year-old act of parliament, but essentially neurodiversity could be grouped in as discrimination on a disability basis. Now,
Okay.
now some neurodivergent people perhaps would not like to be seen as disabled. It's just simply looking at things in a different way. So
Mhm.
that's potentially somewhere where the law has to catch up with society.
Mhm.
But in the meantime, that would be a good place to start in terms of finding out about your rights. So through ACAS, through the health related information. And I would also say, don't rule out your own GP, your own centres where you might go to,
Mhm.
but also potentially an occupational health referral through your employer to
Mhm.
determine what might be available for you in terms of what we generally call reasonable adjustments to make it easier for you to work in your employer's workplace or at home, wherever you do work.
And thank you, Richard, because when neurodivergent people are mostly, we try to hide ourselves, and when we are working, we don't think that what is rightful and what is right, and know our rights as well. So in that circumstances, we struggle. We struggle. So I'm grateful that you're working with neurodivergent people as well as neurotypical, and you can understand the differences we may have in relation of understanding employability, in relation understanding what is out there. So specifically, as you said, the disability. Um, yes, most new. I wouldn't say most, maybe many neurodivergent people, they don't think it as a disable. I don't think this is a disability, and we cannot change the law, because if we wanted to change the law to create a separate category for neurodivergent people, because we are not disabled, but we have some needs. Sometimes they are special needs, and sometimes probably their needs to live better life. So, and if you blanketly say we are disabled, no, we are not disabled. Yes, I am disabled due to my brain tumor surgery and other things, that different things, but my brain is fully working, and I do not believe that due to my autism, due to my dyslexic, I am not disabled, because my genetics is different, and my genetic mutation is different. So that's why I'm different. I can work better than maybe uh, some neurotypical person. So we will talk about it greatly. So when when we working in a workplace, or mostly neurodivergent people, they do business, and they are successful business people. So if I'm working for someone, or I'm running my own business, uh, what are the laws to protect ourselves? Like, is there any specific thing that we should refer to, like understanding our engagement with outside businesses, or understanding uh, how we deal with people, and how we deal with the others laws that is governing employability.
Mm, of course. So, in terms of employability generally,
Mm,
there is one thing in particular that I can think of that might help the situation. So, again, it's part of the Equality Act,
mhm,
but it's if an employer has good cause to basically present a medical questionnaire to a potential employee.
mhm,
Now, that's to find out more about their condition. It's not a blanket, you have to fill this in.
mhm,
It is much more if the employer has a reason for asking. So,
mhm,
if, for example, the adjustments, the accommodation, if you like, for neurodiversity might be flagged at an early stage, the employer might be justified in saying, we want to make sure that we're helping you. I mean, obviously, that would be an ideal kind of employer that does that because they're trying to make the workplace more inclusive. But that's one thing in terms of the employed realm that I can think of. In terms of the self-employed realm, I'd
mhm,
be there isn't anything that I can think of in particular.
mhm.
But one thing that I would say is it is a good idea to figure out your community of people to begin with, because that can be just as powerful as any kind of law. It is there to make sure that you know who is safe around you to actually work with, to go to and be honest with, in other words. So don't rule that out because it's definitely worth its weight in gold to have those people who you can have the honest conversations with, whether times are good or bad.
That's great. So, to our viewers today, we have Richard Hiron, the employability lawyer, and I'm Dr. Shah Siddiqui. You're watching our live webinar uh, on LinkedIn and other social media. This is a New Division Business Consortium, so weekly live. And you know that every week we bring new guests. And today we have Richard Hiron, and we're going to be talking employability because when we talk employability, we sometimes ignore as a new divergent person that maybe rights is for same for everyone, as you have mentioned the Disability Act, because we are governed by that one. So specifically, I work as my academic career, I work at the university or I work in businesses as well, and I also have my own initiative to work with and businesses. So one thing that one thing that I know and myself experience, when we go to a workplace, they say, okay, we are um, disability friendly.
Yeah.
Or we are, LGBT friendly, or a lot of other things, friendly things. But when you enter into an agreement or interview. So if I talk about the interview, um, the settings is not out there. Is
Mm,
the setting is not out there for a disabled person or
mm,
for a neurodivergent person, because some universities or some corporations or corporate or SMEs, they accommodate the thing, like, or when you are going for an interview, they will give you some questionnaire that okay, this questionnaire will be asked, because you know that most neurodivergent person, when they go for interview, they are frightened. They are frightened that okay, what question will be asked, how will be the interview, the person they are coming, um, what would be their mood, and a lot of individual things. We because that's why we're neurodivergent, because we overthink sometimes. And um, in that scenario, is there anything specific act there to ask the employer, like, okay, I'm come to this interview, or I just joined today. The first thing I would ask you, do you understand my rights well?
mm.
And if you understand my rights well, then I need the questionnaire first before I go for interview. Can we do that? Or if I'm going for a job, okay, do you have anything specifically mechanism to provide me with? Can we ask them directly, or what should we do?
Absolutely. So, right from the beginning, when you're actually filling out an application form, however that looks, it's actually a situation where the employer or the potential employer, sorry, actually owes you that duty of care to begin with. It's not something that happens when you become an employee. So you apply for the job. The minute that that happens, the minute that you've been applying for a job, you have rights relating to what unfortunately the law might call a disability, even though, as we've discussed, that's not the best way of putting it, because it's more about inclusivity. But the essence of it is that it is intended to level the playing field between somebody who is neurodivergent and somebody who is not neurodivergent, so that they both have an equal chance in that process. So to answer the question specifically, yes, by all means, you can say, I'm a neurodivergent person. Just taking one example out of the many, I find it quite intrusive being on camera. Therefore, if we actually did a virtual interview, I'd either prefer it to be on by telephone, or I'd prefer to have my camera off. So that's just one example out of the many, but it's one way of explaining it. The question then becomes, and it's more likely to arise, first off with the employer, but secondly with a tribunal, if it did get to that stage, is it reasonable to be asking that? So taking the education sector as one, the education sector might say, well, this is a person who is potentially going to be working with young children. We need to have been able to see them before we recruit them. So they might say, okay, we would do an initial interview without the camera on, but we will need to see you at some stage, because we're putting you into a position of great trust with young and vulnerable people. So that's an example of how a reasonable adjustment could potentially work in the circumstances.
That's good to know, Richard. I give my examples most of the time. As I work multiple places, I apply for jobs as well, to be a consultant and maybe to work with specific projects. I also hire people. So all those things, my experience when I'm working, that some employer, if I ask them that, okay, can I have a questionnaire? I was told directly last time when I asked for a questionnaire, they said we wanted to make it inclusive and equal for everyone. So if I give you the questionnaire, the other person, they are joining this interview, we wouldn't, we wouldn't match the criteria. And I think, and you shouldn't ask the questionnaire. They directly told me. But as I know, you can ask it. Because of your disability, you can ask reasonable adjustment. You can ask, okay, what questionnaire you might ask me to prepare myself. Because when we work with, a disabled person or neurodivergent person, I always tell people that my thinking is a Pandora box. And it's millions of information over there. So if you ask me something, you cannot assume that I will get it out at the right moment, because it has to work, and then I will pull the information. Even though I know the information, I cannot produce a good thing. That is specifically if I don't prepare myself. That happened. And I would say most of the viewer today, you probably agree with me, because whenever I'm talking to individual person, neurodivergent person, they talk the same thing. Yes, you are right, because it's like a cupboard, and we will have individual drawers for individual things. So in that circumstances, for many neurodivergent person, if they ask these things, is it rightful way to do it, or is there any other way to do it?
I would say it's all about context. So, taking the example of the interview that we spoke about, the employer only knows what they know. So we call that constructive knowledge. If they don't have any reason to know that a person is neurodivergent, then that doesn't necessarily automatically trigger the need
Mhm.
to make reasonable adjustments.
Mhm.
So it is a little bit of a catch-22. It
Mhm.
comes down to trust, and I appreciate that it can feel quite lonely being a
Mhm.
neurodivergent person, because you take time to warm to people, and there are some people who may never be warmed to at all. The focus on asking for reasonable adjustments is, to put it in a very blunt way, it's there to protect yourself. So if you don't ask, you can't guarantee that you're protected in the first place. But there are certain ways of asking. So you might feel comfortable with the person interviewing you on the day and say, just so that you know, I would preferably like to have X, Y, and Z to make the experience more comfortable for me. And then that way, even though I would feel a little bit sorry for the interviewer in that situation if it's suddenly put upon them that way, there might be ways of kind of flexing the situation. So let's say, for example, that the interview did not take place in a closed room where somebody
Mhm.
might feel quite confined. It
Mhm.
could potentially take place on a park bench in quite a confidential area, literally outside but not too far away from the office, as one example, if that's reasonable in the circumstances. Um, Ever the lawyer, I would say that the more that you can prove in writing, the better off you're likely to be, because if you're relying on verbal conversations that aren't recorded in any way, there is no evidence to show that you have protected yourself.
I totally agree with you because it's like a catch 20 one situation, isn't it? Because uh, if you are saying about equal opportunity, there's different things. Or if you are saying about, okay, how it could be equal, because if I'm giving you the questionnaire before you are even asked for the interview, that's one thing. Another thing, like, okay, uh, it's sometimes it's very rude to ask the employer that I cannot travel, or to turn my video off, and they see it they see it they don't see it in a good way,
Mm.
because many employer, they are not disability friendly, although they say that disability friendly, but we see again and again the reputation that they are not. uh, they are trying, and we need to push them more for them to grow their habits and take more disabled people to workplace, neurodivergent people to workplace, as well as a lot of other things. One thing, I was just talking to someone yesterday. That was my mother-in-law, and we have a nephew, and he has cleft, and when he talks, it was operated, and people can hardly understand what he's saying. Uh, so in that circumstances, that person is always um, frustrated for that okay, can I go for education, and he lives in Bangladesh, and he frustrated, okay, can I go to an interview where I can speak, to come to UK, because they have to do IELTS and others, because when I go and talk, they will hardly understand what I am saying. In that circumstances, if I am going for an interview, if they ask me a question, if
Mm.
I say, okay, you don't understand my thing, so can I have a written, or can I have other means of things? At that point, the interviewer or the company, they will stereotype you, probably, and they will say, okay, we don't need this kind of people in our team,
Mm.
because it's harder for people to work with, because he will take time. People will not understand his talking, and a lot of other things. Many people, they have problems with expressions, non-verbals, and others. In that circumstances, what is my right?
Mm. In that kind of situation, there could be a disability discrimination claim arising from that, because the focus really has to be on, can the person do the job? So that's the whole purpose of the reasonable adjustments, to introduce things that can level that playing field.
Mhm.
So let's say an interpreter might not be the best example, but if it is, for example, a role where somebody is literally based on the other end of a computer, all of their work is done in writing, then not hiring that person could be disability discrimination.
Mhm.
Likewise, if the role can be apportioned in different ways, so let's say that it is a role that involves being behind a screen, but also involves verbal communication, if you could potentially find a reasonable adjustment where one person does all of the written work, the
Mhm.
other person does the actual vocal work, then
Mhm.
that in itself could be a reasonable adjustment. So they've found a split for the work.
Mhm.
So, what I find with employment law generally, not just discrimination,
Mhm.
is it's all about taking yourself outside of that box and thinking logically. How could this work generally, rather than focusing on how it could not work? So, bringing us again back to the question, it's very much that point of, it's potentially disability discrimination. The key thing is for both the employer and the employee to step back and think, okay, how reasonable is this? If I were standing in somebody else's shoes, would this seem logical to me, or would it be completely impossible?
That's quite good to know, Richard. We have our viewers, and to our viewers, today we have Richard Hiron, and he is a employability lawyer. And we have messages from the audience. I will add those messages here. Uh, just uh, just give me a second. And we have Mahbub. So Mahbub just said hello to you. Good conversation. So thank you, Mahbub, for your conversation. We also have Terry Arnold. Um, and I work with Terry Arnold. We work with various projects as a specifically working in digital marketing. So Terry, he said, this is very appreciate to my own personal circumstances, and Richard. And Terry had a stroke, and after his stroke, he had some difficulties. So when we work with Terry, we try to accommodate um, how we can support him better, because that's the first thing. Because when I had my brain tumor surgery, I became short memory, and due to my neurodiversity, a lot of individual things grown in a bad way. So I created this support mechanism to support me, and now I can understand better other people. Like, okay, if they are disabled, if they are neurodivergent, what should we do? How we could respect that? That's the thing you said just earlier, that we should see how we can accommodate things, not like eliminate things. So Terry, thank you for your message, and Mahabub, thank you for your message. To our audience, if you are watching this live webinar, feel free to ask us any question you have through the comment box, and we will try to answer those for you. And today we have Richard Hiron, and I'm Dr. Shah Siddiqui, and we will continue our conversation and discuss more of our personal experiences and a lot of other things. So if you have any question, feel free to ask us. Or after this webinar, if you wanted to continue this conversation, you can find it uh, on our social media, LinkedIn, X, YouTube, as well as Facebook. So we are broadcasting at the same time to these channels. So if you wanted to continue to grow this conversation, Richard is there. He will be notified if you need any specific information you wanted to ask to. or you can ask Richard directly through his social media, through LinkedIn. And I think it's going to be good for have a have an employability lawyer with us to see what is out there, what is our rights, and how we can protect our rights. It doesn't matter what people think. It doesn't matter what we think is the rightfulness of the doing right thing for ourselves to protect ourselves. So thank you, Richard. We're going to be talking more on our disability and other things, Disability Act. You know, uh, specific way. I felt that when we work with under someone or with someone through our businesses, sometimes they discriminate us. Maybe we make some mistakes because disabled people or neurodivergent people intend to, you know, do a little bit more mistakes than others. Sometimes it's not. Sometimes it may be different for individual person. But as a dyslexic person, when I work, I will have mistakes, spelling mistakes, and a lot of other things. Or maybe some people they might have other mistakes. And that circumstances, people sometimes they don't see it right fully. Like, okay, you have done this, that wasn't right. Some people they asked me when I was working with them, they said, okay, you are a doctor and you are making this mistake. How silly you are. Do you think that you are qualified? And that offended me a lot because my talent is not my disability. I have some special needs. I'm dyslexic, and that is my one of my what I would say neurodivergent characteristics that I cannot spell right. I cannot do things this stage. So someone is pointing me that okay, you have passed your doctorate. Maybe someone else did your work and you just got the levels. What we should do that circumstances, how can we protect ourselves in workplace and working with our clients, what is our right. And I hope the many of our viewers will face these kind of challenges in their working lives, and what should we do.
I have no doubt about it. And I've also seen situations where a condition, not necessarily neurodiversity, but a condition generally,
Mhm.
has cropped up during a process like a disciplinary.
Mhm.
And the thing is, if you are, well, being taken through that kind of process, a corrective process, if you like, and your employer or the people that you work with do not know about your conditions, you are really working in your own favor to say sooner rather than later. And obviously, provided that it's genuine,
Mhm.
this is why this is happening. It's because I am neurodivergent and I have this particular condition, or this is what it presents as for me. Because just going back again to an earlier point, if the person on the other side, whether that's an employer or someone who you work with who is not an employer, whether you're self employed, for example, if they do not know that, then it won't be factored in towards, again, the reasonable adjustments, that balancing, that leveling of the playing field to ensure that you're not being put at a disadvantage compared to somebody who doesn't share the same condition. Now, another element to that is if you feel you have to, particularly as an employee, you can raise a grievance to
Mhm.
say, I've told you about this, you're not taking this into account. And this is how it's impacting me. So that in itself could be literally creating an element of harassment in
Mhm.
legal terms, not necessarily in the way that we tend to understand harassment in social terms,
Mhm.
but you're raising the grievance. And if you continue to be treated poorly because you raised that grievance linked to your condition, that could then be harassment from a legal perspective. So there are processes in place, there are things there to help you, but the key thing is that you have to help yourself by triggering those processes in the first place.
Thank you, Richard. I think to the viewers it's very clear. If we are not sure or if we're unsure of supporting ourselves with specific conditions or specific incidents, it's better to contact employability lawyer like Richard and other people that you know your rights better. Because if you have a condition and then if you wanted to work with people, it's better to protect yourself first and then work. But one thing I noticed, when you disclose your disability to potential interviews, sometimes yes, they will call for you interview. They will make reasonable adjustment and a lot of other things. But at the end, they will not select you. So I'm just sharing this from my experiences, and talking to many other individuals, sometimes they don't share that, okay, they are neurodivergent or they have a disability. So when they select it and then they tell them, okay, I hide it because for discrimination. In that some circumstances, what is my right? If I wanted to let my employer or let the businesses later after I have a deal in place.
Yeah, you can ask them to factor it in.
Mhm.
The thing is, if they find out that you have any kind of condition that is recognized as a disability, and they then suddenly withdraw the job offer, then again, we're in disability discrimination mode.
Mhm.
So there can be situations where that has happened, and unfortunately, it does happen. The employer might try to smooth over why the job is not being offered, but you do have a weapon in your arsenal, which is called a subject access request.
Mhm.
And this ties into, and I hate describing it this way, GDPR,
Mhm.
but essentially data protection, because GDPR is just one part of data protection, not the whole of it.
Mhm.
And you have that power to essentially ask for information relating to you that
Mhm.
the employer or potential employer is holding. It's important to make it a very focused request. So,
Mhm.
something that extends over goodness knows how many months, how many years, is probably going to be unenforceable. And likewise, something that asks for absolutely everything is going to be far too broad.
Mhm.
So if you can focus it on something like the reasons why I was not employed, or the reasons why the offer was withdrawn, then that's quite specific. And that means that you can then look for documents that give you the reasons, which in themselves can be an element of peace of mind, but also from a tactical perspective, can be a kind of evidence building exercise if
Mhm.
you are seriously considering going to a tribunal.
I understand, Richard. And it's sometimes is difficult when we go through with interview process or when we go through recruitment and as well as dealing with engaging with customers. It's difficult, and you will see that employer, they will safeguard themselves in a way. So I have learned that, okay, we have found someone better than you. So
Mm.
in these circumstances, your application, we will not go through with it to the next stage. And you know, many people, many neurodivergent people will face the same thing, same writings, same thing. Okay, you are not the best suitable candidate for this position, but we got someone better than you. So how do you know that? Okay, the due diligence of this one,
Mm.
they are not neglecting you, or they are discriminating you,
Yeah.
because they're going to be safeguarding themselves anyway. So what is the meaning of asking them this information?
The meaning of it is, first off, that kind of peace of mind element, which I don't think should be discounted, because there are so many tribunal claims that are raised based on not the best evidence, shall I say.
Mhm.
And if you have the peace of mind answers, that can make things a lot easier. So, if, for example, the answer is the reason you didn't get this job is because that person had this qualification that we really want, but you unfortunately did not, then that's pointing away from neurodivergency or any kind of condition being the reason for why you weren't hired for the job. However, if you have a reason that's given, if you have the paperwork essentially saying we didn't hire you in favor of somebody who has exactly the same qualifications as you, then that's raising the possibility of, it's a neurodivergency. That's why they didn't want me. So it's quite a guessing game to some extent, and it's not always the case that you will get something quite clear in black and white.
It's not.
Also, I would say that it's worth bearing in mind that if you're going around doing a subject access request, raising a tribunal claim, then there is potentially a reputational damage caused to you in doing that. So the subject access request is behind the scenes and should be, unless it's revealed publicly in a court or tribunal. Like if you go to a court, those decisions, even if a claim is settled partway through the process, can still be published online. Specific public guidelines are met that they need to be kept behind the scenes. So I think it's very important to bear in mind that if you go around potentially suing everybody who doesn't offer you a job, then you could firstly be very embarrassed, and secondly, in the worst case scenario, the courts and tribunals can actually say, you bring a lot of nuisance claims, so we are going to prevent you from doing that in the future. And they have done that notably times.
Yeah, there's a say catch 21 situation, because when neurodivergent people, they will go for, or disabled people, I would say, they will go for interview. The refusal letter will not reflect that, okay, they are discriminating you, but you have a feeling that you are discriminated, because you are discriminated in many other applications as well. All the time, receiving a message that we found better candidate than you, and we're not going to take this job to the next stage. It's not like that you will receive it for you understand that why it is happening, because there is a mechanism on the act that, okay, if you hire one disabled person in 25 people, then you are safeguarded because you don't need to hire more. And if that is one disabled person, means entire entity, like, okay, covering disabled, covering LGBTQ, covering neurodivergent, covering a lot of different things, genre on that. So you cannot specifically tell an employer that, okay, you are discriminating us.
I think there's also a very important thing to factor in here in the law. So nothing, no tribunal, no court in the land is going to make a business that does not want to hire disabled people change its focus. They could have any number of claims against them, but a court or tribunal will not say you have to change the way you do business. They just will not do that. So I've known clients who have simply wanted to walk away because knowing that the employer is like that has been enough for them. They know never to approach them ever again, and they just think, I want an easy life. I've also had others who have really wanted to go the distance, who've ended up with what they consider to be a very healthy settlement so that they can move on to another better life. So I think it's an important point to raise, because the law will not solve all issues. It will look at the legal issues, and again, it's very important to set out that a tribunal expects both sides to settle a claim. Quite honestly, it is an overburdened legal system that focuses so much of its messaging on have a sensible conversation and
Mhm.
bring this to an end without having to come to us at all.
Mhm.
So yeah, I think in that essence, it's important to recognize that there are two avenues going on. There's the legal one, which expects you both to have a sensible conversation and only go to the tribunal if you have to. And then there's the cultural issue, which is quite frankly right down to the employer and whether it's willing to have a look at itself.
Mhm. Thank you, Richard. I think our viewers they are enjoying this webinar. We are knowing more and learning more, and I think we will learn more with continuous conversation. So, to our viewers, thank you very much for your contribution today and supporting us. So, if you wanted to ask us question, please feel free to ask us through the comment box. We will continue this conversation. We are nearly end of our session. We just have 15 minutes left and we're going to be talking more. So if you wanted to ask us any question, please feel free to ask us through the comment box or continue this conversation. Today we have Richard Hiron, an employability lawyer, and I'm Dr. Shah Siddiqui. So we run this program every week and we talk on a specific topic. So today we are covering employability law for neurodivergent individuals. And I hope you're enjoying this webinar, and please support us through social media as well as let other people know about this webinar, because we intend to cover a lot of individual topics to support our neurodivergent and disabled population and aware them, because the main core thing that we are talking, Richard, today is if you're not aware, if you don't want to accommodate people, we cannot make it, can we? So we have to aware we have to aware the employer, we have to aware neurodivergent people, disabled people. Yes, there are rights out there, there are acts out there, but if we do not, follow those things, no one really care about them, isn't it? So we need to think about our own rights. We need to think about our own access. Um, reasonable adjustment and a lot of different things. In some people, they don't care. We can point them, okay, there is an act, and there we are. As an employer, is a human, or you to support us. It's going to be inhuman if don't support us. That's the thing. And for our viewers, well, next week we're going to be talking a very specific subject: understanding neurodiversity and mental health in children. So you know that neurodivergent a person and the children, they will have mental health issues. My son, he's autistic. He's very clever, but you know that we have mental health issues. We ask questions. We don't understand certain things, certain behaviors, and we don't act like the neurotypical people they wanted to see us. So if you wanted to join the conversation, please register your events. I will add the registration links in the comment box. I will ask my office to do that. And if you wanted to register, please register and share this webinar to people that we can support individual neurodivergent people and disabled people. And Richard, just going back to the conversation, thank you for your contribution today. You know, we know all of those things. We know all of those acts. We know the employer. Some of them are supporting us. Some of them are not. If we see conflict of interest in that region, what the best way to resolve them? If we see, shall we follow the traditional way, or because you have seen many cases, so what would be your suggestion to the viewers that there is a conflict of interest or there is a conflict of something? What would be the best way to deal with those situations?
I would suggest that in even though it might not sound helpful on the first blanch,
Mhm.
using your employer's own processes, so the
Mhm.
grievance procedure, the whistleblowing procedure, um, even if you have to, asking for an occupational health referral. And I have seen that very recently where an employee, and it should not be the employee having to ask for an occupational health referral, but I
Mhm.
have seen a situation where an employee literally had to say, please refer me to occupational health so that we can all understand what's going on that bit better. It's working within those processes to ensure that you're using them protectively. So an employer might say, I think you need to go for training. Well, that's only so helpful, but if the training is not tailored towards somebody with a neurodivergent condition, then how is it really going to help? But the fact that you have done it, however illogical it might seem, and the fact that you have said, look, I'm neurodivergent, I am likely going to be approaching this in a very different way to most people. It shows that you have used every process, you've been cooperative, and if you're then poorly treated because of it, that essentially reflects on your employer, not you, because you have been doing everything reasonable that's required of you. And they, on the other hand, may, and I'm not saying that all employers are like this because they're not, but they may simply have just a closeted view that again comes down to a cultural point. But the law in that situation is more likely to be on your side because you have shown that you are cooperative, that you're willing to use their systems and processes. And the key word in employment law, you've been reasonable.
I understand, Richard. So when we are in workplace, you know that inclusivity is the rightful thing to talk about, and our the employer and employee. So we see a different face sometimes. I become aware, the people I'm working with, businesses and others, that when they see that, okay, you are a neurodivergent person, the eyes is different of your colleagues, because they're going to be seeing you, okay, you are receiving some benefits or some treatment they are not entitled to. And then it's become clash and a lot of other things in workplace and other way. So in that circumstances, what should we do? How do we work with this?
Of course. I would say that the first and foremost thing is to let your line manager know.
Mhm.
If your line manager turns out to be the problem, then it's worth having, well, essentially going over their head and speaking to the person who manages them.
Mhm.
In an ideal world, any kind of complaint or grievance related to that should be resolved informally.
Mhm.
But the key thing is that, again, you've started that process, you've kept things in momentum, and you've tried to find a reasonable way to resolve everything. So I would not suggest, unless it's a worst case scenario, that you immediately pick up the phone to ACAS and start a process through them,
Mhm.
because they will ask you the obvious question: what have you done to resolve this informally?
Mhm.
Have you been to a formal grievance? There's
Okay.
also another element involved. If the situation is so bad that it requires it, but the relationship is still salvageable, then mediation can be a good way of resolving things as well, to
Mhm.
actually reach an agreement where people are not only agreeing legally to behave in a certain way, but they're also perhaps better informed as well because they've been through that process.
Thank you. Thank you. It's really good information, I would say, to our viewers. If you're watching this webinar, please feel free to contribute, and thank you for your contribution who are watching this, and let other people know about this. And if you have any problem, please feel free to contact Richard Hiron, and he's an employability lawyer and he can support you with your specific questions. I'm not a legal person, so uh, please contact him if you wanted to discuss anything, because you will probably in future you might have come through or struggles, or so a lot of individual things can happen. So at that time, it's better to know how you can safeguard yourself, how you can protect your interest, and a lot of other things. So, Richard, if we talk about neurodiversity or disability and the Disability Act and the successes of our rights, you have helped many people. So among them, if we compare, like how many people they dispute and how many people they suffers, or what's the success rates if you wanted to dispute, and what are the angles out there if you wanted to become successful on your disputes?
Yeah. I think it would be 50-50. Some
Mhm,
of them just want an easy life. Others have been pushed right to the brink, and they
mhm,
are literally, I'm going to the tribunal, which might sound very, very bold and courageous,
mhm,
but I do sometimes question the motives. I don't say that they aren't entitled to go,
mhm,
but I think if it is purely with the focus of, I want my day in court,
mhm,
that's not a helpful mindset. I'd
mhm,
say focus on the resolution, focus on reframing this from something bad that has happened to
mhm,
something productive that can be achieved. Because the law is fantastic when it rules in your favor. But going there with a kind of battle hardened, I'd even say perhaps criminal law perspective of this is what a tribunal will achieve, clients do tend to get quite surprised when they find out that it's not, how can I put it? It's not an adversarial atmosphere. It is not like going to the Old Bailey. It's not like getting some judgment of right or wrong. It
mhm,
is literally an examination of what has happened, and it can be emotionally devastating to clients. It
mhm,
involves them having to go through quite sensitive evidence.
mhm,
And I have seen clients who sometimes have seemed years older from the time of starting the legal process to finishing it. So I think all of that is very well worth considering, not in terms of your right to access and exercise your rights,
mhm,
but in terms of the impact that it can potentially have on you going forward. That a mindset of kind of battle hardened can really take away from you in other ways. So it really is productive to have the conversations around what what do I feel I'm owed? What can you, Mr. Employer, give me that will satisfy me to literally move on with my life? And I think that's probably the most valuable piece of what I can offer in terms of not just the law, but also this, your well being.
Thank you, Richard. That's really helpful. My last question would be, before I ask you the last question, I'm going to ask the viewers, if you wanted to ask question, please feel free to ask us. We can extend this webinar a couple of minutes more, and talk about neurodiversity, talk about employability, and talk about other things. One thing is that if I'm discriminated, I know that I was discriminated in some of the instances, and I did not do anything. But can we later? But when I realized that okay, I should act on that specific elements.
Mm.
Maybe some years later, that I think that I was discriminated. Can we do like that, or it's if it's over, it's over. You don't need to go over there again. Like having a peaceful life rather than going into struggle.
Yeah, there is quite a strict time limit on these things. So
Mhm,
typically, that time limit runs 3 months,
mhm,
less 1 day from the date of the last act of discrimination. So the last act of discrimination could be your dismissal, or it
mhm,
could be failing to give you a reference that everybody else receives.
mhm,
So from that last event, that last date, you've got 3 months less 1 day first off to contact ACAS to start a process called early conciliation. And then that essentially extends the time for you to be able to exercise your rights in a tribunal. But sadly, if it's years down the line, it is much more a case of a lesson learnt. And if it happens again, which touch wood, I would hope it doesn't. But as you've said, there are circumstances where it happens again and again. Take that lesson on board, because the next time it happens, if it happens, it's a lesson learnt and it's an action that you can take to defend yourself.
Thank you, Richard. I think this information will be very, very valuable to many of the neurodivergent and disabled people. They are watching this webinar and they will watch this record later. So I just wanted to ask you the last remarks, if you wanted to say to our viewers, and then we will end the stream.
Well, that's very kind of you. And I mean, the main thing for me is to thank you for the opportunity to discuss this with you, and also to your wonderful viewers for their support. So thank you ever so much for having me, and to them for being here.
Thank you, Richard. We are just nearly end of our session. So Richard, thank you for your support and contribution today. And to our viewers, thank you very much for your support and contribution. So if you wanted to support us, you can support us through the social channels, LinkedIn, X, and other social medias. We will come back to next week and we will talk about mental health in children, neurodivergent children. And we will have a very, very, I would say, interesting session to talk about it, because when it comes from mental health, when it comes for children, we are very worried and we need to support them. We need to support our future generation that they think, okay, they are right. They don't have problems, so they can grow their imagination. As neurodivergent people, we are more imaginative, and we need support specifically for some of our things that we cannot do better. So to our viewers, thank you very much for your time today, and we will see you next week to another episode of Neurodivergent Business Consortium's live webinar. Until then, please stay tuned, please support us, and if you wanted to ask us any question, please ask us through social media, through these events, and you continue this conversation. And if you wanted to ask anything to Richard, feel free to contact him directly. Otherwise, I'm Dr. Shah Siddiqui, and I'm going to say you bye-bye and see you next week. Thank you very much, and bye-bye.